And from that conversation, we move on to our Vox Pop for the week. What do legal practitioners think of the inconclusive elections? Is it setting a dangerous precedent, as some think? We have a few reactions up next.
The electioneering process, is a function of INEC. INEC is an independent body, and so they have guidelines that regulate the conduct of election. And also, the law also provides for basic minimum requirement that must be satisfied for a candidate to win an election. So, and those requirements must be met. So, if those requirements are not met, INEC has the power to declare such an election inconclusive. More so when the candidates that contested the election have more or less the same results, or the difference, the gap is not so wide. Now, for instance, there are in some places where there are toggle, ballot box stuffing. Of course, INEC has the power to cancel those elections, but again, they cannot disenfranchise those people. So they need to conduct a fresh election in those areas to make sure that everybody exercises its right to vote.
If the courts now do not determine the matters, the actions filed in those states, that's Adamawa, Rivers, as well as Bauchi, where INEC wants to conduct a rerun election and also or continue with the collation. If the cases are not determined before the swearing in or before all those issues are and the court declares the winner, then that means by May 29, some states will not be having new governors in. Now, and another issue that will now come up is who will continue to be at the helm of affairs of those states. Will it be the sitting governors whose tenure would have elapsed at May 29? So these are some very naughty and novel issues that will really come up as a result of the whole inconclusiveness and everything. But looking at it again from another point of view, the inconclusive election sometimes can also show how popular both candidates are, and it shows the strength of the political parties, the contending parties in those states. Unlike the way whereby we had previous years, you just had in some states also up to now, it's just there's really no competition. So you don't even have a choice whether you vote. If you vote another candidate, he's not going to win because he's unpopular or his political party is unpopular. But with what you are having now, it's really a very important, and it shows a good sign for our own democracy. Let's say, for instance, another is KANU. We can see how tensed the whole and how competitive and the whole election was in KANU. So that also shows that yes, our democracy to an extent is growing.
The law is clear, and I think from the events so far reported, I think the INEC to some, and then what INEC presented to the public, or that is in the public domain, I think to some extent the situation has presented itself to declare such elections as inconclusive, and INEC has done so. By law, they are the only body to announce the election, the result of an election, and they have done so in accordance with the law, not any other. If there's anybody that says no, the situation as presented by INEC is not correct, then he has to prove cogently, maybe by presenting another result to say INEC result is false. The situation is not as presented by INEC. But in this situation, it will be by law. It will be very hard to believe because INEC is still the only by law, empowered by law to manage our election. And in the course of management, it can declare elections whichever way it pleases. Either declare the winners or the loser, or as well the way it is as inconclusive.
Per place, if an election is declared inconclusive, before then, the INEC will fix a date for another election to take place, so that the election will be concluded, and somebody must be announced as the winner. But what I'm saying is that even if any other person, the opposition group, if any person feels cheated, the person wouldn't have to do any other thing. The person will go to election petition tribunal. But the person that is declared winner must take office before the election is nullified.
And from there, we move on to the courtrooms. Here's a recap of some of the top stories from there.
We begin with the report that the Presidential Election Petitions Tribunal has granted Atiku Abubakar and his party, the PDP, permission to serve their petition on President Muhammadu Buhari through his party, APC. The PDP and Alhaji Atiku Abubakar, who, by their petition, are challenging President Buhari's victory in the February the 23rd election, applied for leave to effect service of the petition on the president on the grounds that they were having difficulty serving him. The three-man tribunal, after listening to Chris Uche, a senior advocate of Nigeria, who moved the ex parte motion filed by the PDP and Atiku, granted them permission to serve through substituted means. Justice Abdullah Boki, who led the panel, ordered that President Buhari, who is listed as the second respondent to the petition, be served through any senior official or an officer of the APC at the party secretariat in Abuja. Three more parties have since joined the PDP to challenge the outcome of the presidential election, bringing to 4 the number of petitions against President Buhari's election. The other three are the Hope Democratic Party, HDP, the Coalition for Change, C4C, and the People's Democratic Movement, PDM. In OSUN State, Governor Adegboyega Oyetola, who contested on the platform of the All Progressives Congress, has asked the Court of Appeal in Abuja to reverse the majority judgment given on March the 22nd by the OSUN State Election Tribunal. The tribunal had, by a majority judgment given by 2 of its 3 members, voided the election of Governor Oyetola and pronounced Mr. Ademola Adeleke of the People's Democratic Party as winner. It then asked the Independent National Electoral Commission to issue him a certificate of return. In a 39-ground notice of appeal filed on March the 26th by his team of lawyers led by Wale Olanipekun, a senior advocate of Nigeria, Governor Oyetola faulted the majority judgment on the grounds that it was perverse, replete with contradictions, and not supported by evidence led by the petitioners. Governor Oyetola wants the Court of Appeal to uphold his appeal, set aside the majority judgment, and dismiss the October the 16th, 2018 petition by the PDP and Mr. Adeleke. Still on election-related matters, the Court of Appeal in Abuja has upheld the victory of the EKITI State Governor, Kayode Fayemi, of the APC. A 3-man panel of the court, in a unanimous judgment, dismissed the appeal by the PDP and its candidate in the election, Kolakbo Olushola, for lacking in merit. The court upheld the January the 28th, 2019 judgment of the Ekiti State Elections Tribunal, which sat in Abuja owing to problem of insecurity in Ekiti State. The tribunal had in its judgment upheld Mr. Fayemi's victory and dismissed the petition by the PDP and Mr. Olushola on the grounds that they failed to prove their allegations, among which was that the election was marred by irregularities. Justice Stephen Ada, who read the lead judgment, resolved the 7 issues identified for determination in favor of the respondents, the Independent National Electoral Commission, APC, and Governor Fayemi. Away from election matters, the Federal High Court sitting in Abuja has ordered the rearrest of the self-proclaimed leader of the indigenous people of Biafra, NNAMDI KANU. Justice Binta Nyako gave the order after revoking the bail granted to the IPOB leader. She explained that the court gave the order because Mr. KANU had failed to appear in court after his bail was granted in April 2017. The judge also ordered that trial would continue in the absence of the IPOB leader and directed that a bench warrant be issued for his arrest. She then adjourned the case till June the 18th. Justice Nyako had granted Mr. KANU bail on health grounds on April the 25th, 2017 and asked him to present 3 sureties. She had also warned him that the bail will be revoked if he flouts any of the conditions. Mr. NNAMDI KANU and 3 others are facing charges of treasonable offences before the court. And we round off with the report that the Court of Appeal sitting in Lagos has set aside a Federal High Court judgment which exempted the Nigeria Liquefied Natural Gas Limited from levies imposed on it by the Nigerian Maritime Administration and Safety Agency, NEMASA. A 3-man panel of the court, led by Justice Lawal Garba, dismissed the judgment of the lower court for lack of fair hearing. The appeal court also ordered that the matter be taken back to the Federal High Court and be reassigned to another judge for retrial. In October 2017, a Federal High Court, Lagos, presided over by Justice Mohammed Idris, while delivering judgment in a suit filed by the NLNG against NAMASA, held that NLNG was not liable to pay 3% gross freight on its international inbound and outbound cargo, sea protection levy, 2% cabotage surcharge on all activities carried out for and on its behalf, as well as other sundry claims as insisted by NAMASA. Justice Idris also held that the NLNG was not liable to make the said payments to NAMASA and that all payments already made by the NLNG to NAMASA should be refunded to NLNG forthwith. Dissatisfied with Justice Idris' decisions, NAMASA then filed an appeal before the appeal court challenging the judgment on the ground of fair hearing, among others.
And that's our program this week. Thank you very much for watching. Be sure to catch the repeats on air or watch via our YouTube channel. I am Shola Shayeli. See you next time.